All righty. Good afternoon, everyone. Welcome to today's commercial real estate webinar on mitigating risk in commercial and real estate purchase and sale agreements. We have Dan Meyer, a member of our corporate and business transactions and commercial real estate practice groups, joining us today. He'll be at the controls. Very excited to have him. Before he does get started, just a couple of announcements. Number one, if you would like to ask a question of Dan, you can ask that by entering your question into the Q&A function of this Zoom webinar, and that's located at the bottom of your screen. Dan will take as many questions as he is able to within our time. So, just go ahead as you think of your question. You can enter it in that box, and he will get to those after the fact. Now, secondly, the recording of this webinar, as well as Dan's slides that he will be presenting to you all, will be available 24 to 48 hours after this presentation. Those assets will be emailed to you, and they will be available to you should you want to have them in the future. Dan, excited to have you here. I appreciate you being here, and the floor is yours.
All right. Thank you, Roger. I appreciate it. Thank you, everybody, for joining us today for a little pre-Halloween discussion of risk in purchase and sale agreements for commercial real estate. As you can imagine, the universe of potential things to discuss on this topic is pretty substantial. Certainly far more substantial than we could ever even hope to address, let alone dig into on a 45-minute webinar. That said, I tried to highlight some of the ones that I typically see on a regular basis, but just know that this is in no way meant to be an exhaustive coverage of all these topics. All right, so starting off with kind of what you might even say would be kind of the early parts of the typical commercial real estate purchase and sale agreement, some of the primary topics that are negotiated regularly, particularly surrounding the deposit itself, obviously the amount of the deposit, events or deadlines that may trigger the deposit going hard, i.e., becoming non-refundable to the buyer. And then also sometimes things that trigger the need to pay one or more additional deposits. Obviously deposits, regardless of when they go hard, they generally will remain applicable against the purchase price. There are some exceptions to that, but those are typically one-offs where, the parties have negotiated that the deposit is essentially, kind of almost like an option payment in that context. There are multiple functions relating to the diligence, permitting, and damages under a commercial real estate PSA. Beyond just it functioning as the security for the seller, essentially agreeing typically to take the property off the market and negotiate exclusively with that particular buyer. We oftentimes see multiple deposit structures. There's some pros and cons to this, but they're typically used because they offer the buyer flexibility and to pursue their diligence and their permitting activities over a longer period. And it also gives you the ability to essentially have kind of a staged deposit structure that, if right off the bat after your initial diligence, for example, that the property's not going to be feasible for your intended use, then obviously it's great that you don't then have to go through the process, cost, and expense of going through sometimes a protracted permitting process. So the use of one or more deposits are fairly typical in these types of deals. Just a quick comment on diligence in general. We see a lot of times, and I'm sure folks on this call have seen the use of, data rooms, drop boxes, sometimes referred to as data rooms, but essentially one or more, boxes that all of the diligence can be uploaded. This is particularly pertinent to seller diligence. It's typical during the negotiation of the purchase and sale agreement, whether there was a signed LOI or not, there may be the giving of some early access to some of those diligence materials to prospective buyers or the buyer. When that happens, I always advise my clients that are on the seller side, and really it makes sense for the buyer on the buyer side. If they're going to do any kind of early access to those types of diligence materials and or to come onto the property, I generally recommend that a site access agreement be entered into between the parties. That type of agreement typically mirrors the things that would be addressed in the purchase and sale agreement itself regarding the conduct of buyer's due diligence. With respect to the seller due diligence, sometimes it's delivered ahead, sometimes it's delivered at signing, but more often it's within some relatively short period of time after the signing of the P&S. It is very important on the seller side that you include, and you'll see here at the slide that at the bottom of the slide, the final bullet, I talk about some of that language. The seller will want to provide those materials in seller's possession and or under seller's reasonable control. And we generally want to disclaim and limit any liability, with respect to the diligence that we do provide. So, it's a typical thing that's done. It generally will help expedite the buyer's diligence. So it's usually something that the seller will want to cooperate on, but you just want to make sure that you don't get yourself or your consultants, engineers, surveyors, and so forth into any kind of hot water by not properly disclaiming the ability of the buyer to rely on those materials. Similarly, and kind of along a similar line, we want to be particularly careful with respect to environmental diligence. Oftentimes, you'll see a purchase and sale agreement that will permit the buyer to conduct what's known as a phase one, a non-invasive environmental inspection of the property, which is largely based on historical and some initial on-site work. But the phase two, sometimes purchase and sale agreements will require that the buyer actually get the seller's permission before conducting the more invasive phase two. But regardless of how it gets handled in the purchase and sale agreement itself, the most important thing is that we want to make sure that in addition to all the other disclaimer and limitation of liability and indemnification, that there's strong confidentiality, particularly with respect to the environmental. There's also this concept of whether or not you see it more commonly, particularly in ground leases, dirt up ground leases, but even in certain purchase and sale transactions, there may be scenarios, maybe situations where the buyer wants to have, at least initially, as limited as possible involvement, although some sellers will want to have more involvement. But generally speaking, as long as it's not at the seller's expense, the seller will want to reasonably or will reasonably cooperate with the permitting process that's being spearheaded by the buyer. Then it just comes down to a question, and this comes down to how we draft, but the degree to which the seller wants to be involved, wants to have control, do they want to have any active involvement in the permitting process, or is it just something that they want to monitor? They want to get copies of notices, correspondences, things of the like. And then there's also the ability, if it's wanted by the seller, for them to actually step in and help get the buyer over the finish line on permitting. Again, that's something more typically seen in ground lease scenarios, but you do see it sometimes in purchase and sale. A big advantage to using a multiple deposit structure is that the buyer has some degree of ability to limit the money it puts at risk. This is both in terms of the deposit, total deposit monies paid and at risk, but also transactional expenses. I had mentioned earlier the ability to do an initial diligence period prior to commencing the permitting period, the entitlement period, for example, by paying perhaps a lower initial deposit, doing the diligence, deciding if the property is feasible based on the diligence before you pay an additional deposit and or start spending money on the entitlement and permitting process, gives you that flexibility to be able to save some money there. Okay, let's see here. So now we're getting into the other very hotly negotiated, debated, so forth, portion of a purchase and sale agreement, which is, of course, the representations, warranties, and covenants. Covenants, I'm not going to spend quite as much time on because they are exactly what they would suggest, right? So the seller is going to agree, they're going to covenant to do or not do certain things from the time of the selling of, the time of the signing of the purchase and sale agreement up to and including the closing, and in some cases with with the language providing for this, certain covenants may even survive the closing for some short period of time. We'll get more into survival periods later. On the reps and warranties, particularly obviously in commercial real estate transactions, most deals are going to be as is. So, they're also sometimes referred to as is with all faults. But essentially, any seller of a commercial real estate asset is going to want to, as much as possible, make the deal as is, limit the express reps and warranties they make, and really try to shift the diligence responsibility onto the buyer. So that's the goal of the seller. The buyer obviously wants to chip away at that. I have an example, although I think anybody on this webinar that has any experience dealing with these have certainly seen these big all caps provisions. This one here is actually this one actually goes on for another page and a half. We cut it for brevity, but essentially you can see whole multiple page long as is clauses, and they again are generally aimed at trying to alleviate any post-closing liability for the seller and basically shift all the responsibility for the examination and inspection of the property onto the buyer. Now, the buyer's counsel is going to want to start to chip away wherever possible on that as is language. And then they're also going to want to insert in as many express seller reps and warranties as they can conceivably get away with. Later on in this, I'll get into a little bit more about, basic versus fundamental reps and warranties and materiality and things of that nature. But just know, generally speaking, fundamental warranties are generally the ones that are the most oft thought about. And, later on when we're talking about rep and warranty insurance, we'll talk a little bit more about that. Obviously, with the reps and warranties, there's the rep and warranties essentially being made by the seller as of the date that the purchase and sale agreement is signed, but then will also be expected to provide what's known as a bring down certificate, which is a standard deliverable at any commercial real estate closing. And that bring down certificate just certifies all of the seller's reps and warranties, or at least the fundamental ones, as of the date of closing. Okay. So let's talk a little bit about carve-outs. Disclosure schedule carve-outs are more often seen and really kind of have their genesis in merger and acquisition deals, M&A deals, but generally speaking, they are just as applicable and can be used for commercial real estate deals, particularly where the seller knows that there's some aspects of what they would otherwise have to rep and warranty to that they wouldn't be able to make without disclosing it. So by having disclosure schedules, you're actually able, the seller, to call out certain exceptions to their reps and warranties that they know to be in existence or will be in existence at the time of closing, thereby carving them out from the rep and warranty. The schedules, which are generally attached much like exhibits to the actual purchase and sale agreement, will then refer back to the specific subsections of the seller rep and warranty that it is addressing. I give an example here. This is a typical rep and warranty, except as set forth in Schedule 10D here too. Sellers not received notice of any, and this, you guys can see it. I'll let you read it, but essentially it deals with government notices and, actual or threatened. So that would actually allow the seller to be able to list in the schedule to the purchase and sale agreement the actual individual items that they seek to carve out, the things that they know would otherwise violate the reps and warranties they're being asked to make. Next, another big one is the quote unquote knowledge standard for the reps and warranties. This is certainly more pertinent to the seller reps and warranties, but also can appear sometimes in any reps and warranties that the buyer would give. The above example that I gave, which had to relate back to the disclosure schedules, relating to the receipt of government notices, is the knowledge standard. So why is it important? Typically a seller, as I already mentioned, is going to want to make as limited the number and scope of reps and warranties as possible, but not only will they seek to do that, but the seller is going to want to limit that standard of duty to those matters that they've already discovered or have been disclosed. So in addition to that, they want to limit this to what they know of. So oftentimes what you'll see, and you may see actual knowledge, and oftentimes you'll see a definition of what constitutes actual knowledge. But generally speaking, actual knowledge is essentially without any duty to conduct inspections or further investigate any matters addressed in any report or other material developed during the diligence. And that includes seller diligence and or buyer's diligence. So in other words, usually there will be an individual, oftentimes defined as the seller representative. That's oftentimes a principal or some other employee with the most hands-on knowledge of the things that will be asked to be, repped and warranted to. And we'll talk a little bit more about the limitation of the liability on that individual person, but we'll basically want to limit it to the buyer representative's actual knowledge of the matters being repped and warranted to. And that further narrows the window of potential pitfalls that a seller could run into with respect to violating reps and warranties. Let's see here. So let's talk a little bit now about the rep and warranty. I think that's where that brings us. Yep. Okay, so again, similar to the use of disclosure schedules, sellers use and rep and warranty insurance on commercial real estate transactions, finds its roots in the M&A world. These policies have really started to become even more commonplace in M&A over the last 15 to 20 years. And as they have become more commonplace there, they've started to become more commonplace in commercial real estate deals. Essentially some of the main providers we can discuss after, but generally speaking, rep and warranty insurance is an insurance policy. The typical cost is usually somewhere between 3 and 3.5% of the total insured amount, which usually relates to the overall purchase price of the deal, but also will generally factor in certain other amounts, certain other matters. Liability certainly being included in that. Basically, we started to talk about, and I'll delve in a little bit more about, what your basic versus fundamental reps. Those will generally have different quote unquote survival periods, not only in the purchase and sale agreement, but also in terms of the policy itself, with fundamental usually having a longer survival period of 6 years versus basic reps and warranties generally being 3%. Rep and warranty insurance in the vast majority of cases is used by seller, but I would point out that it is available to buyer as well, but they will not both be able to have rep and warranty insurance on the same deal. So it's either or, and it is most typically the seller. And it does give some additional peace of mind for the sellers. It also helps the buyer as well because it can help buttress any kind of caps on indemnities. You'll commonly see different indemnification baskets in an M&A deal and their transactional documents, but you may sometimes see the different treatment of indemnification caps, the amount to which the seller agrees to indemnify to cover damages for any violation of reps and warranties. So rep and warranty insurance can be a very useful tool there. Kind of similarly to what I was getting into previously, we see environmental liability insurance and ELURs coming up a lot, particularly where the property being transferred is environmentally sensitive. Environmentally sensitive. And we want you want to the extent possible during the negotiation of the purchase and sale agreement, again, to the extent possible, you want to forwardly address and come to understand all the environmental issues related to the property. Obviously, there's certain things that will be knowable based on the seller diligence and just general knowledge of the subject property. Before you start to dig in on the further investigations, phase ones, phase twos. But generally speaking, the buyer is looking and would like to the extent possible, because they may not be able to if they're already a party, a responsible party, for example. But they'll want to try to terminate their ongoing liability effective as of the closing date. So it's super important where, there's unknown on the environmental to do the diligence and make sure that there's no unknown environmental, and reportable environmental conditions present on the site, to understand whether or not there may be one or more underground storage tanks, still on the property. And how old are they? What are the condition are they in? Where are they located relative to any improvements on the property? In other words, will they be accessible? Have they been sealed? Do they need ongoing tightness testing? These are all things that can and will come up when there's environmental issues with the property. Environmental insurance policies, very similar to rep and warranty insurance policies, are available. They are generally tied not only to the overall deal size, acquisition price, but also some of the other, underwriting factors at play. Environmental history, present condition, relative creditworthiness of the parties, not just the parties to this agreement, but also any other responsible parties along the chain of title on the property. The degree of an involvement, is this a brownfield? Are we dealing with the EPA, or are we just, dealing with local or state environmental agencies? The degree to which there needs to be remediation and ongoing monitoring activities. These are all things that get kind of weighed into. Environmental land use restrictions. There are obviously recorded documents on title that restrict certain uses of the property where environmental issues are present. The bona fide prospective purchaser, which is really something that you deal with for brownfield properties with the EPA, but many, if not most states have basically adopted their own state ancillary to the bona fide prospective purchaser, and it just allows a buyer of an environmentally sensitive property to agree to and record certain things and obtain, usually in the form of a letter of compliance from the environmental agency, that allows them to have certain controlled deviations from the things that are restricted. So, for example, in most environmental land use restrictions, the number one use to be restricted will be residential. And there are instances where by going through the process with ELURs and the bona fide prospective purchaser process, you can ultimately get a letter of compliance and get a restricted permission to use for residential purposes. Um, Talking a little bit about remedies, damages, and survival periods. One of the things that I talked about earlier when we were talking about deposits is that the deposit is often your liquidated damages. So that's something to take into consideration when the parties are negotiating deposit amounts, although they are, again, can be broken up into one or more installments, an initial and additional deposits. But the important thing to keep in mind is that where you have a termination right, whether it's at the end of the diligence period or the review period or the permitting period, whether it's applicable to the full deposit or certain installments of the deposit, more often than not, a seller's sole remedy is to keep that deposit as liquidated damages in the event that the seller is unable to close. Excuse me, the buyer is unable to close. Okay. Um, and that's similar to for the seller will want to obviously look to cap its potential damages for its failure to close, to just deposit, forfeiting the deposit back to the buyer. And depending on the deal, depending on the structure and how much diligence and permitting goes into it, a seller may agree to some capped reimbursement of buyers, hard and soft costs incurred, but that's fairly rare. Usually it's just limited to the deposit back. But again, it's going to depend on who the parties are and other factors like that. Um, Similarly, we already talked about obviously the buyer is going to want to limit their damages. And they may waive the right to seek specific performance against seller in return for that. Both parties should seek to mitigate potential future liability by using survival periods. We talked about this a little bit before, but usually the survival periods are really mostly focused on the reps and warranties. You may see different survival periods for different reps and warranties, fundamental versus basic. But generally speaking, on sophisticated commercial real estate deals, you're going to typically see a survival period anywhere from 6 months to 2 years on the high end. And more often than not, you're not going to see anything that exceeds 18 months. For some, like I said, some fundamental reps and warranties, particularly those where they may not be immediately knowable inside of a year, for example, you may see a more extended survival period. But survival periods are very important because generally speaking, absent fraud, there is not much a buyer is going to be able to do post-closing, and certainly prevail on in any event. Okay. Any questions?
All right, Dan, a big thank you to this point. This is so much appreciated. Really do appreciate you being here. And I know, just as a reminder for everybody that is here in the Q&A feature at the bottom of your screen, you can ask Dan questions. And I just want to make sure that you guys, everyone here is aware of that. But Dan, as we wait for those questions to come in, I do have a few of my own.
Okay.
The first one being, how often do you see buyers counsel succeed in getting around or severely limiting as is clauses in these PSAs?
Well, not very often. I personally, unless the client specifically has a reason and is very adamant about having something be as is as humanly possible, I generally try to use language that strikes a little bit of a middle ground. That's not to say we don't want to be very clear about what the as is clause is accomplishing, But I find that when you go too heavy-handed, it's inevitably going to lead to buyer's counsel trying to spend more time chipping away at that. I'd rather have a very standard as is clause that's not terribly controversial, and then do more of my battling in the rep and warranty sections. So it really depends. I guess the most direct answer to your question there would be it depends on the party, right? Their relative strength in the negotiation. So
Understood. Okay. Well then, yeah, we do have one question that's come in, and it looks like they're still typing.
okay.
So we'll just let that come in. But in meantime, here, Dan, next question for you is, what's a typical survival period for seller reps and warranties?
Yeah, so I think, I actually just kind of went over that a little bit, but again, just like everything else, it depends on the parties, depends on the assets, the more complex the assets are. Are we talking about somebody buying a single tenant standalone drive-through asset, or are we talking about somebody that's acquiring a shopping center where, there's going to be extensive reps and warranties, rent rolls, things like that regarding, the number of tenants and other conditions of the property. So it just depends, but like I said, typically you're going to see anywhere from 6 months to 2 years is generally.
Okay, understood. Yeah, and in the chat feature, or excuse me, the Q&A box, Dan, I'll just read this question from Frank. And
Sure.
his question is, are you seeing many non-refundable deposits on commercial development projects?
Yeah, so that's a great question. I have seen more of them. One of the places where you're obviously going to see them is in any auction type of offering, right? Any deal where you might have multiple bidders and the deal is basically go right to purchase and sale. Um, whether or not the parties are going to agree to have all or any portion of a deposit be non-refundable from the outset. Again, is gonna depend on several factors, but usually I might see it more where a buyer needs a longer diligence and permitting period. So it is essentially more similar to a naked option, right? Like a typical option agreement where, you're basically paying from the outset to have the exclusive right to inspect, negotiate, and finance the property. So I would say they are still not typical, but you see more of them. But where you do see more of them, the context usually, uh, you know, lends itself well to it.
Got it. Okay. We have our next question here from Christian. Do you find having a responsible knowledge party and specifically naming an officer, et cetera, in the reps and warranty section an effective way to keep the seller honest?
I think, that's a great question. I think there's an argument to say that it does. I know that when I work with my clients, whether it's on the sell side or the landlord side on a lease, particularly the folks that are, the ones responsible for facilities management, property management, overseeing construction, things like that. Um, they're the ones that typically have the most institutional hands-on knowledge, at least with respect to the physical conditions of the property. And then you might have somebody who, whether they're the controller or the head of leasing, they may have more of the institutional knowledge. So sometimes will call out more than one person or just not call out one person at all. And look, the reality of it is, and I always have to reassure all of our folks that I do have act as the, representative of seller. They're going to not only be covered by, their typical insurance as a employee, an agent, or officer director of the seller entity, But we're going to have pretty substantial liability limiting language in the purchase and sale agreement itself to further limit any potential personal liability. But I would say that on some level, to go to Christian's question, I do think that when individuals are personally called out, it may result in some degree of wanting to be more forthcoming. So,
Understood. Okay. Thank you for that. Thank you, Christian and Frank. Dan, just a few other questions for you while we still
sure.
have some time. I know we talked a little bit about fraud at the tail end of your presentation, but how does fraud impact the legitimacy of survival periods?
Yeah, it doesn't. So don't do it. No, kidding aside, one of the things that, and this is also the case in any M&A deal, any agreement underlying an M&A deal, but even in purchase and sale agreements for real estate, one of the things that buyer and sellers counsel are going to go back and forth on is materiality qualifiers, right? So we talk about fundamental reps, we talk about basic reps, but we also talk about, this is also the typical fight between negligence versus gross negligence, right? So what level of misrepresentation or omission is material, right? How do you arrive at that? Now, us attorneys will spend a great deal of effort trying to suss that out in the agreement itself. In our drafting, we'll want to talk about what constitutes a material, misrepresentation or omission. But generally speaking, whether it's material or not, if it's fraud, it's fraud. If you knowingly and intentionally, going back to our knowledge standard for reps and warranties, once you have knowledge of something and you either failed to disclose it and had a duty to do so, or you materially misrepresent it to the point of it being useless, then you're crossing into fraud. And now the only limit on your future liability is going to be, you know, basically statutes of limitation on bringing a fraud claim.
Understood. Okay. All right. And in terms of if people are interested in learning more about reps and warranties insurance and or excuse
Mhm.
me, some environmental insurance policies, who do they reach out to?
Yeah, so I mean, obviously, aside from speaking to their attorneys, and hopefully us, um, you know, the big players that I typically come across, whether it's in, M&A or real estate, and whether it's environmental or rep and warranty, the big players tend to be the Aons, the Chubbs, the Marsh McClellan, and Gallagher's another big one, particularly for rep and warranty, but they also do a lot of environmental. I've done a lot, particularly on the brownfield stuff with Chubb. They kind of specialize in that. But all four of those do it regularly. They all have their own dedicated departments now that work on these types of policies as they've grown in popularity and usage. So,
Sure. Understood. Okay. We do have one other question here that's come into the chat, but excuse me, the Q&A box. It is from anonymous attendee,
oh
and
boy.
but here's that question. New York is famously a caveat emptor state where the buyer is out of luck if something is not caught during the due diligence period. Any states in your experience that have protections for buyer as a matter of policy?
So I would just make the very important distinction between residential and commercial. In any residential purchase and sale agreement, I'm not sure that there's any state in the United States of America that does not have a similar law and does not treat residential level end user consumers differently than they do commercial participants who a certain level of sophistication is imputed upon by the courts. So to answer that question, yes, on certain types of transactions involving certain types of properties, you can very much avail yourself to state laws to try to add additional protections against any kind of misrepresentations, omissions, and things. But generally speaking, I can certainly speak for Rhode Island and Massachusetts. Anything involving commercial, I'm not saying the courts won't, give some leeway to the buyer and not necessarily, strike every argument based on the existence of an as is clause. But they're going to be a lot more loath to do so. So I would say that, on commercial purchase and sale agreements, one shouldn't put too much stock in those types of laws and protection.
Understood. Okay. Well, thank you for that question, Mr. or Mrs. Anonymous.
Mhm.
And, seeing that we've run out of questions, Dan, I think maybe I just turn to you for a closing statement. If there's anything you additionally want to share with people, the floor is still yours.
Sure, sure. Yeah, before I let everyone go, I wish everybody a happy Halloween tomorrow. And the one thing I would say for those of you on this webinar, the earlier in the process, I know for those clients, they're going to say, "Oh, we don't necessarily want to get our attorneys, we don't want to get the clock running on billing too soon." And I understand that, but I will say this, by getting us involved as early in the process as possible makes it that much more likely that we'll be able to bake a lot of this into earlier drafts of the purchase and sale agreement, and have those discussions up front and early, which will ultimately not only make the process go smoother, but will generally result in savings in the long run for you anyway. So my big thing with it is, don't wait until you've gotten the draft P&S to start talking to your attorneys on these things.
Yeah, I think the real answer is an ounce of prevention is worth a pound of cure.
You got it.
All righty,
Thanks, everybody.
Dan. Well, Dan, thank you so much for your time. Members of the audience, thank you for your time. We're going to wrap it up here. And again, if you missed it at the top of the program, we will be sharing the PowerPoint presentation and a link to this presentation, a video link to this presentation to all registrants in the next day or two. So be on the lookout for that. It'll also be available on our Darrell Everett website on the resources page. And also then too, just again, a big thank you. Pretty crazy that we're down to the last 2 months of the year. And yeah, there you go. Thank you, Dan. Thank you, audience. Well, take care.
Thank you.